Well, good morning to the unexplainable number of people who follow my videos. I generally don't do blogs, but this time I think I have to. You may be aware of the ongoing murder trial, or self-defense trial, of Kyle Rittenhouse, the Kenosha kid. And I'm going to make a case for the need for a directed verdict to acquit Kyle Rittenhouse of these murder charges. So that you know, a judge is allowed to step in either when petitioned by either the defense or the prosecution to instruct the jury to render a verdict, and he can actually tell them what the verdict has to be based on the condition of the trial. Now, this is the case for a directed verdict to acquit Kyle Rittenhouse. Given that the trial is not of the killings and the shooting and the wounding, because those are established facts. We know who did it, we know when, we know where, we know who not victims, we know who the recipients of the bullets were. What is actually being tried is the claim of self-defense. The prosecution has the sole job of attacking the elements that are required to validate a claim of self-defensive use of force or lethal force. And those four elements are: the attack has to be an unprovoked attack. The person who does the shooting, who claims self-defense, cannot have been the aggressor. The second is there has to be an immediate peril. The situation has to be immediately, pressingly dire. The third is there's no practical alternative, or there was no practical alternative when the threat appeared, meaning that there was no viable opportunity to retreat, there were no less lethal options available, de-escalation could not or did not work, etc. And the fourth requirement is the person claiming self-defense has to be able to demonstrate that there was a reasonable fear of receiving severe harm, injury, or death as a result of this unprovoked attack. Now, as I said, stripping away any one of those factors is enough to invalidate a claim of self-defense. And doing only that, is the task of the state's prosecution of these murder charges. All they have to do is take away one of those elements from Kyle Rittenhouse's assessment or account of the events, and the claim of self-defense is invalidated. That's all they have to do. That's all they've been trying to do, theoretically. And as far as I can tell, all they've managed to do is to confirm each and every one of those elements. Repeatedly. Their own star witnesses have repeatedly, by their own testimony, sworn testimony, both in direct examination and cross-examination and in video, have proven every single one of those four elements. They've literally made the defense's case. Now, I'm no lawyer, but the requirement for a directed verdict seems to be pretty clear. When a judge determines that no reasonable jury could conclude that the prosecution has successfully made their case, he can direct them to acquit on those grounds. And right now, as of last night, Monday night, it seems to me that the prosecution has not only failed to make their case, but they have negatively succeeded in an epic manner. I mean, it's mind-boggling how incredibly stupid the prosecution was in putting their star witnesses on the stand, because I mean, it's just you'd have to watch it. You'd have to read the transcripts or watch the excerpts. It's amazing. when the prosecution lead actually face palms, when their star witness, the Grosskreutz, whatever the hell that stupid, whatever his name is, the guy who got his bicep turned into a canoe, he flat out admitted that Kyle Rittenhouse didn't shoot at him until he, Grosskreutz, approached Kyle Rittenhouse with a gun in his hand aimed at Kyle Rittenhouse. You can't get any more immediate, pressing, credible threat than that. And everyone has agreed that Kyle Rittenhouse was doing everything he possibly could to de-escalate and to escape and evade, and he got basically trapped repeatedly and then attacked in an unprovoked manner with weapons or with clear intent to cause severe harm. It's not arguable. There's so much video evidence has been available to everyone since 3 days after the event, but I mean anyway, the prosecution has made the defense's case. Now, wise and cautious observers will point out that even in the case where the prosecution has utterly failed to make the basic elements of their charges stick, judges are loath to short-circuit a jury and to give a directed verdict. And so they should be. I mean, in that specific case, where the prosecution has failed, the judge should be very leery about interfering. No argument from me on that. However, I'm not arguing that the state has merely failed to make their case. What I'm arguing is that they have instead proven the defense's case so thoroughly that they have invalidated the state's ground for prosecution of these charges. And that is a distinction with a difference. It's past time for this farcical, politically driven, malicious prosecution to be terminated on those grounds with not just dismissal of the charges, but an acquittal and vindication for Kyle Rittenhouse. That's all I've got to say on it.